SJC-12196, Commonwealth v. Stephen James.
Good morning, Ms. Scapicchio.
Good morning, Your Honors. My name is Rosemary Scapicchio.
Wait, give us a second. Give us a
sorry.
Give us a second. I know that you're usually very restrained. But today,
Usually.
we're going to allow you to release your enthusiasm.
Thank you. I
Okay,
appreciate that.
Good. Now you may begin.
Thank you. Good morning. My name is Rosemary Scapicchio, and I represent Stephen James. We're here today for this court's, it was a reported question with respect to an issue that I think is an issue of first impression here in Massachusetts, and that is whether or not the 33E gatekeeper provision should apply to a juvenile who was convicted of first-degree murder, but since his sentence has been reduced to second-degree murder, and who had not filed a motion for new trial prior to his direct appeal. And I think this case turns on this court's interpretation of capital case. And it depends on whether or not this court determines capital case by the crime or capital case by the sentence. And we're here to urge you to determine it by the sentence.
Now, before you go there, is this a matter of be careful what you wish for?
No.
Because if you get this, do you not lose the plenary review that these cases presently enjoy and the opportunity for 33E review, including the opportunity for us to reduce the level of a conviction to a more appropriate level where we think that is in the interest of justice?
I do not believe that that issue is before the court. What I think is before the court is the restriction as it applies to 33E, not the right as it applies to 33E.
But if it's not a capital crime, then is it not outside the realm of 33E, and would the case then not go to the appeals court and be heard by us only on an FAR?
Unless this court fashions something different for juveniles convicted of first but sentenced to second. And I think that issue is not briefed before you today. I think there'd be a due process argument with respect to that, but that's not what we're arguing today. Today we're only concerned with the restriction that 33E imposes with respect to the gatekeeper provision. It's that restriction that we're asking I'm sorry.
Go ahead.
It's that restriction that we're asking this court to strike as it applies to juveniles convicted of first but sentenced to second. Just the restriction with respect to the gatekeeper provision. That's what we're asking this court to focus on and leave for another day in a different case, because I think in this case, Mr. James did get 33E review, and so I think it's a different case and a different set of facts.
But it's all going to turn on whether or not it's a capital case. Both of those questions would turn on that, wouldn't they?
I think that it would turn on a capital case, but different things would happen. In other words, if this court determined that it's not a capital case, a situation where a juvenile is convicted of first but sentenced to second is not a capital case for the purposes of the restriction.
So would you have to define capital case differently for the restriction and for whether or not it would be 33E review under the statute?
I think it's a different issue. I do.
No, I understand why you think it's a different issue, but capital case is a capital case, right?
Right, it is.
And the statute actually defines what a capital case means.
The
The case in which the defendant was tried on an indictment for murder in the first degree and was convicted of murder in the first degree. That's what the statute says. It doesn't say it's for one purpose, that definition, and another purpose for the restriction.
You're absolutely right, because I don't think anyone anticipated the sea change that Miller brought upon the court when we decided that juveniles should be treated differently. And so the question that needs to get before the court, if you're going to look at the right, the 33E right to review, is the due process and equal protection rights of juveniles similarly situated. That's not the issue that I think we briefed today. It's not the issue that's before the court today. We're concerned with the restrictive nature of the gatekeeper provision, because what happens fundamentally for someone in Stephen James's place is that a direct appeal was already heard and denied. This new sea change happened with respect to juveniles. He files a motion for new trial. He gets no evidentiary hearing. And now the issue is...
Well, let me ask you, is that what this case turns on? I mean, because you could conceive of a juvenile convicted of first-degree murder who has moved for a new trial and has gotten the entire case reviewed under 33E standards, right?
Yes.
And then moves for a new trial because of new evidence or something else and is denied, and then that would be gatekeeper. That's not this situation, because here Mr. James did not get a motion for new trial reviewed under 33E.
That's correct. He did not have 33E.
Is that the turning point? Is that the distinction
I think
you
it's a
wanna-
distinction that the court needs to consider, absolutely. I think that in situations where there was no motion for new trial before the direct appeal, so there was no 33E review of the issues involving the motion for new trial. And the reason for that is that if there is a restriction and the juvenile has to go through the gatekeeper provision, and the gatekeeper doesn't allow that petition, then the juvenile is restricted and probably procedurally barred from having the federal court review that under a Hague petition. And so it's the restrictive nature of the gatekeeper provision that will not only restrict the juvenile in terms of his right to appeal, but also restrict the juvenile in terms of where he gets to go or she gets to go from a contrary decision of a single justice on 33E gatekeeper provision restriction review.
But isn't the restriction and the 33E inextricably intertwined? Because if you've had plenary review, then you need to have the gatekeeper provision.
Well, I would say that in adult cases, absolutely. But there has been a sea change with respect to juvenile cases in the way that we treat them. And so if we have declared, which this court has, juveniles have to be treated differently.
Well,
So-
Ms. Scapicchio, it's a capital case until the legislature says it isn't, right?
No, because if you look at the intent of the legislature in terms of a capital case, it appears from all of the notes, and I think some of the issues are contained in our reply brief, that their intent was to find a capital case based on the sentence, based on the fact that you are serving life without the possibility of parole, which is...
What? I mean, it's defined in the statute as a first-degree murder conviction. It says nothing about the sentence. The sentence is totally irrelevant
But
to this consideration.
I don't believe that, because when the...
Show me where in the law your position is
Well, the
justified.
legislature at one point had amended 33E review to include second-degree murder convictions, and then amended it out, and decided it wasn't appropriate for 33E review because it was a second-degree murder conviction. And that's essentially where we are with Stephen James right now.
But they didn't change the definition of capital case.
They did not.
Okay,
They did not.
so what are we to take from that?
We're to take from that if you're an adult and you were convicted and you get 33E review, you're done. If you're a juvenile, juveniles are different. And so I don't think that the legislature considered the sea change that happened after Miller and what we should do with juveniles in terms of, because if this happens,
Up to the legislature to fix this problem?
I think that when you have an imprecise and unclear statute as it's applied to a specific group of individuals, in this case, juveniles convicted of first and now sentenced to second, it is incumbent upon this court to interpret that to make sure it withstands constitutional scrutiny. And that's really what we have to do here. And in that vein,
So what's the constitutional problem? He doesn't have a right to appeal after appeal. I mean, no person has an absolute right to an appeal in the way that you're proposing to us. I mean, he's had his review.
well, he's had his review under 33E before this issue arose. I absolutely agree with that. But now that we have determined that juveniles are different, now that we've made that statement and we've changed the law with respect to juveniles, we have to look at the statute to see whether or not it is more restrictive. Because
Well,
right now,
your client is in a different position than the broader class of juveniles who may be coming later. Your client has had 33E review.
right, but I think this court has said on a number of occasions it can't be complete review where there's such a sea change. And that's where I think we need to look at what the statute's intent was. And if you look at the legislative intent, it was intended to apply to crimes with the most serious sentence. And what that does realistically to people like Stephen James is treat him differently and give him more restrictions, not less restrictions, because we've decided juveniles need help. So we can't then say, but we're going to restrict them more than other people, because juveniles convicted of first-degree murder don't have to go through the gatekeeper. Any adult convicted of second-degree murder doesn't have to go through the gatekeeper. So in situations like this, how are we treating Stephen James differently, making it more restrictive for him to get this court to review the underlying issues on a motion for a new trial? It would be an equal protection violation, and we're challenging the statute as unconstitutional as applied to Stephen James.
Just suggesting that your client may be in a different situation since he's already had 33E review than other juveniles who've been convicted of first-degree murder who have not had the review. So why should your client be treated the same as those juveniles convicted of murder who have not had 33A review? We might have a different rule for them, but what about your client? He's already had it.
He did have 33E review initially when he appealed his conviction, but that was before Miller. And I think if you recognize that Miller says juveniles are different, then you can't make it more restrictive for them to get review. And that's essentially what the gatekeeper provision of 33E does.
That's what I'm having trouble with. I don't understand why it's more restrictive for juveniles than it is for adults.
Because in this particular case,
Only as applied.
as applied, and is there a rational basis for it? And given Miller, there can't be any rational basis to make it more restrictive for someone who was 17 years old at the time of the conviction to get this court to review that conviction.
Okay, that's what I'm just, I hear your words. I don't understand the concept that you're trying to.
Well, the concept behind it is that if we've decided that juveniles are different, if we've decided that they need some extra attention because they think differently, their brains are different, and we've already declared that they should be treated differently with respect to sentencing in Massachusetts. We've already said that. So if that's the premise that we're working under, that juveniles are different, then how can we make it more restrictive for the very specific facts involved in this case with Stephen James for him to get this court to review his motion for a new trial? And that's what we're going to, if we impose the 33E review on him, then he's more restricted than anyone convicted of second-degree murder, which is the sentence he's serving. He's more restricted than any juvenile that gets convicted of first-degree murder because they don't have to go through the gatekeeper provision.
Had a more extensive and sweeping review of his direct appeal than anyone else in his position would have had, you're saying, because he got 33E review.
Because he's a juvenile.
And no other juvenile, no one convicted of murder too would have gotten that.
Would not have gotten the 33E review.
Right, so they wouldn't, so that immediately puts them on a different footing.
It does, but it's the restriction that we're dealing with here. In other words, we're making it more difficult for Stephen James.
So we're only supposed to look at one side of this?
No, I'm not saying look at one side. I'm saying recognize what we've done with respect to juveniles, recognize that they are different, and don't make it more restrictive, make it at least the same as people who are similarly situated.
But
and
I
so
think
if
what
he's
Justice Hines is saying is, you got the wrong client for this issue. You've got the wrong client. You got to tie gatekeeper 33E. You have to tie that to plenary review, and you've already had plenary review.
No, I don't think you do. I think if this court was to do anything in this case, you could strike the gatekeeper provision as it applies to 17-year-olds who were convicted of first but doing a second-degree murder sentence. Just like we did you guys did in the murder statute when you said they no longer can be sentenced to life.
Here too.
Life without the possibility of parole. So you could strike that sentence as it applies to juveniles, just like this court did in the murder statute. It absolutely should not apply as a restriction. It should not be harder for juveniles, whether they got plenary review or not. That's a different question. That's an issue for a different day, I agree. Whether it's a right, you have a right to a second bite at the apple, that's a completely different issue. Right now, we're just dealing with that clause that requires a restriction, and a more onerous restriction on my client, who was 17 at the time, who was convicted of first, and who's attempting to put forward a motion for a new trial challenging that conviction.
Let me ask you this. You agree that your argument is exclusively constitutional and not a matter of statutory interpretation?
I think you have to interpret the statute in order to determine whether or not it's constitutional.
Well,
I don't think you can separate it out. Because if you look at the statute, I think Justice Lenk is right. The statute says what it says. Capital murder is first-degree conviction. But if you look at the statute, the murder statute, the sentence for murder was life without the possibility of parole.
But
So it's the same thing. You have to look at it.
The legislature knows how to change the statute, even putting aside the differences with second-degree murder in and out. We've got now the habitual offender statute infused into 33E.
The habitual offender statute, I think we dealt with in our reply brief. I think it's way different than what happened with respect to the murder convictions. The habitual offenders addition under the gatekeeper provision of 33E review was opposed by this court. This court wrote in opposition to adding that type of crime to 33E review. And the legislature decided anyhow to add that, but it was based on a reaction to a killing of a police officer in a crime bill that was a compromise. It had nothing to do with
But don't we
murder
have to look at
defendants.
the text there too? I mean, and there too, it's not based on the sentence, it's based on the crime.
In that particular case, with respect to the sentence, I think it is based on the sentence, Your Honor, because if you look at the amendment, when they had included second-degree homicides as 33E review, and then they took it away, it was the only difference between first and second is the sentence. It's both life. One is with the possibility of parole, and one is without. So clearly, the legislature sent a message to us indicating that this restriction should not apply to individuals who are convicted of second-degree murder, because they then repealed that and didn't allow it to apply to second-degree murder convictions.
Okay, thank you.
Thank you.
Ms. Lee, good morning.
Good morning. May it please the court. Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. The defendant is asking this court to take juveniles in the defendant's position out of the gatekeeper statute, and the reported question included whether this was a capital case and whether such defendants are included in the gatekeeper provision. And the Commonwealth's answer to the reported question and the defendant's claim is, as it always must be, to look at the statute. This is a statutory right, and the legislature has determined who has this right. And the definition turns on the conviction, not the sentence.
So as I understood the argument, it is, the statute says what it says, but even if it's clear, we have to look at it somehow in terms of its purpose in order to address the constitutional claims that have been raised.
Correct. And as my sister said before me, this is both statutory construction and a constitutional claim. And in terms of the constitutional claim, the defendant stands in the same position as other people who were convicted of first-degree murder. That is the relevant information that the legislature has set forth. The fact that he has gotten a benefit as to his sentence because of age does not change his conviction. His conviction is first-degree murder, and the legislature has given him this statutory right. And so, moving towards the end of my argument in my brief, you can't treat juveniles who stand in the same place as adults differently under the Constitution. If an adult convicted of first-degree murder has rights under Section 33E that are by statute, that this court and no one but the legislature can take away, then the juvenile should also, who's convicted of first-degree murder, have those rights that the legislature has granted to him and this court, and no one but the legislature can take away those rights. And that's in re galt. Just because a juvenile has a different sentence does not mean the juvenile is not entitled to due process and all his rights under constitutional law.
Ms. Scapicchio doesn't necessarily disagree with that. She just says that you should still not have the gatekeeper.
Correct. And what the defendant is looking for here is a windfall. They've gotten a lesser sentence, and now they want to have all the rights under the statute to be applied to them, but none of the restrictions that go hand in hand with that. And when you look at the footnote in Brown, and when you look at this court's decision in Commonwealth versus Smith, you see that the plenary review, direct review to this court, and what has since come about through case law, the substantial likelihood of a miscarriage of justice, the more favorable standard that arises from that under plenary review, that goes hand in hand with the gatekeeper. The whole purpose of the gatekeeper statute is to prevent repetitive or insubstantial claims, and that's in the quote, the lengthy quote in my brief from the Smith case.
Well, I mean, the whole gatekeeper thing emerged out of Sacco-Vanzetti case, in which half of Massachusetts appeared to be upset that they'd been executed, and the other half was upset that it took so long to execute them. And so we have this balance in which the SJC does plenary review, and then after the SJC decides it, it's rather limited review, no doubt for the purpose of not delaying the ultimate execution. How does that history play into the existing statute where we no longer have the death penalty?
You know, I think it's an excellent point. We see ourselves now in divided times just as we did in Sacco and Vanzetti. And what happened in the wake of Sacco and Vanzetti was that the legislature said, wait a minute, we want a better backstop on these capital cases. We want our Supreme Judicial Court to give consideration to the weight of the evidence. It's not just whether there's an error of law. And so in Sacco and Vanzetti, this court did its duty and found no error of law and affirmed the sentences and convictions, and the men were executed. And the legislature, in the wake of that, and it didn't happen right away, but years later, the legislature put in 33E that this court would consider the weight of the evidence. If we take juvenile defendants out of the definition of capital case, we are stripping them of those benefits that the legislature wants them to have because of the nature of their conviction, not their sentence, because of the infamy of the crime. The sentence was important in the past. The sentence was decisive in the past because it was death penalty cases. And in 1974, the legislature amended that definition out of death penalty cases and put first or second degree murderers. And then this court, as I note in a footnote in my brief, found the death penalty to be unconstitutional in Massachusetts under that statute. And then this legislature amended that statute again to take out second degree murderers and focused on the conviction of first degree murders.
So, Ms. Lee, you're sort of preaching to the choir, but not addressing Ms. Scapiccio's point. Your point is well taken that gatekeeper and plenary review are inextricably intertwined. What she's saying is, okay, but nonetheless, if you're a juvenile and you have a motion for a new trial, you shouldn't have to go through the gatekeeper. That's her argument.
Right.
What you're saying, I completely understand. I think she'd agree with it.
And what I'm saying is, if you take them out of the definition of capital case, you are endangering their statutory rights. Because if they're not subject to the gatekeeper under the statute, then they're not subject to plenary review and a consideration of the weight of the evidence and direct review to this
So you
court.
fundamentally reject the argument that these things are separate by virtue of the purpose that they serve.
Yes, and that's the language of the legislature, and that was what this court said in a footnote in Brown when this court was leaving the question for another day, said, and plenary review and gatekeeper. And the gatekeeper serves an important purpose, and I think it's important to note, one, under Trigonis, the gatekeeper statute has been found to be constitutional. Two, it doesn't deprive the defendant of all right to subsequent or multiple appeals after the direct appeal. It just says the defendant has to show a new and substantial issue. And so to the extent that my sister in her brief and during her argument was saying, well, it's different now because we know more about juvenile brain development. We have new understanding of juveniles. Well, that is not relevant to this court's consideration of the statutory construction of the constitutional claim, because if they have a new and substantial issue, they can present that to the gatekeeper. And that's the whole purpose, to prevent repetitive or insubstantial claims after plenary review. And I would note that the legislative intent is very clear here. For 40 years, the sentence has not been, more than 40 years, the sentence has not been relevant to the definition of capital case. In 2012, it was 2 months after Miller came out, this court has acknowledged in my sister's argument, the habitual offenders were added, and habitual offenders have a variety of sentences, not all of which are even life sentences. And then in 2013, the legislature amended the juvenile jurisdiction statute so that 17-year-olds were no longer considered adults. That's Chapter 119, Section 54. That was in direct response to Miller, which talked about Miller had the 18-year-old bright line rule in it. So that's an obvious reaction to Miller. In 2014, the murder statute itself was amended, 265 Section 2, to address, it's 265 Section 2, small b, to address juvenile murderers from age 14 to 18, so that there would be a fixed time period for their parole eligibility in the Superior Court judge's determination. And you can see that language at Commonwealth's addendum, page 6. Either of those amending times, when the legislature was addressing the murder statute or the juvenile jurisdiction statute, in direct response to Miller, those would have been ideal times for the legislature to make the determination that sentence is now again appropriate consideration for whether something is a capital case or not. They did not do so. And that means something under Commonwealth versus Martin, cited in my brief. When they amend some statutes and not others, you infer what the legislature is saying. This defendant's decision before this court said that he was a juvenile convicted of first-degree murder subject to 33E. So the legislature would be well aware of it. This is not the only case, obviously, where a juvenile was subject to 33E. The legislature would have been aware of it. They were clearly aware of Miller. They did not change the gatekeeper statute. And this court is bound by the definition of the legislature for 2 reasons. One, because of separation of powers. The legislature determines who is subject to that statute they set forth. And 2, because of in re Galt. If you take juvenile murderers out of the definition of capital case, then you will not be able to protect them by statute any longer from not having direct review to this court, not having plenary review. It will no longer be a determination of law, but a determination of discretion by the court and whoever is sitting on the court. And I would suggest to this court that that's not appropriate. A juvenile convicted of first-degree murder, the highest crime in our state, stands in the same position as an adult convicted of first-degree murder, and he is entitled to all the rights that follow along with restrictions of the gatekeeper, but all the rights that adults are. And I would ask this court not to take them out of this constitutional statute, and it's been found constitutional in Trigonis, because defendants do not have rights to automatic multiple appeals, and that's Bruno. The defendant here has a possibility of getting a new appeal under the gatekeeper by showing a new and substantial issue. And if he does so, he will get another appeal. If he does not, he will not, and that is what happens to first-degree murderers.
I know that the gatekeeper statute imposes on the single justice that standard of the new and substantial issue. But if a judge denies a motion for a new trial that does present that type of issue, is in a non-murder case, on review, what is the standard?
So, I'm sorry.
On appellate review.
The non-murder threw me off.
The non-murder case.
Non-murder
What's the appellate standard for reviewing the denial of a motion for a new trial?
So I believe this court set forth the discretionary standard in LL versus Commonwealth on the review of a denial of a motion for a new trial in a non-murder case, and it goes, there's an automatic right of appeal because a non-murder case does not have protection under 33E.
So it's abuse of discretion.
So it's abuse of discretion standard for appeals from denials of motions for new trial.
That doesn't happen very often, though.
I think in LL versus Commonwealth, in the footnote, I believe Justice Botsford wrote that decision, talked about The prior standard was essentially as often as pigs fly, or something along that, as a colloquial phrase, and that the standard in LL, the change in the standard in LL was to reduce that burden to show an
More
abuse of
pigs could
discretion.
fly, I guess, huh?
I'm sorry?
The idea being that more pigs could fly?
No, but that they wouldn't have to show that pigs could fly. I think there was a concern about having to find that the motion judge was not conscientious. But also, it indicated that there was some reduction in the burden in the LL versus Commonwealth case, which I'm sorry is not cited in my brief. I didn't anticipate the question. I see my time is out, so thank you very much for your consideration.
Thank you.